of you combined represent over 60 years of federal civil service, and we are grateful for your time. Special congratulations to you, Judge Conrad, on your recent retirement from district court work in North Carolina. As a former prosecutor, I know the American judicial system is the gold standard for fair, equal, and impartial treatment under the law. It is a critical part of our democracy and has been since our nation's founding almost 250 years ago. It is incumbent upon us to ensure that our partner branches of government have the tools they need to execute the duties of their office. Courthouses across the United States serve not only as a place of employment, but as a symbol of what makes our country great. But many of the courthouses need repair to keep pace with modern times. At the same time, the judicial system faces the reality of modern threats to both its physical and cyber security. Protests across the country have damaged federal property and threatened the safety and security of judges, officers, and staff who work every day to serve the American people. Countries like China and Russia focus their efforts on gaining access to the IT systems of the judiciary to undermine American democracy at its core. And now federal judges find their names in the news or on social media, and they are met with online vulgarity, in some cases physical harm to them or their loved ones. As the Judiciary's fiscal year 2026 spending plan reveals, it takes significant resources to operate the federal judiciary. We need to understand their priorities and resources, how they're being deployed across its divisions, and why. Judge St. Eve and Judge Conrad, let me again commend you on your leadership during these unique and challenging times. I look forward to working with you. I now recognize the ranking member for his opening statement.
Right. Thank you very much, Mr. Chairman. I want to thank Judge Conrad and Judge St. Eve for being with us and for the meeting we had, which was very helpful as a preface to this hearing. If the judiciary, Mr. Chairman, is to meet this pivotal moment and preserve the rule of law, we must ensure that it has the resources and independence it needs to function as a co-equal branch of government. That's why I'm very disturbed to see certain House Republicans call for retaliation against judges who rule on the law as they see it, but with which the present administration may disagree. Judiciary Chair Jim Jordan sent a letter asking this committee to limit funding the judiciary uses to issue and enforce injunctions. Other House Republicans have filed articles of impeachment against judges, not for any misconduct, but rather for ruling against the administration. Federal judges who block Trump's illegal executive actions are just trying to do their jobs and interpreting the law. That is their role, and that is critical to our democracy. Many were appointed by Republican presidents. Some were even appointed by Donald Trump himself. I agree with Chief Justice Roberts' assessment earlier this week that retaliation against them has, to use his words, endangered the rule of law. You can't claim to stand for law and order when you threaten the independence of the branch responsible for upholding law and order. Some of my colleagues across the aisle agree, and I hope they'll stand up for the judiciary. Our subcommittee needs to ensure our courts receive the resources they need to fulfill their duties under the Constitution. Doing so is especially important considering the recent continuing resolution did not provide any funding increase for the judiciary in fiscal year 2025. 6 of the 11 judicial branch appropriations were funded at a freeze for a second year, meaning they were forced to continue operating at fiscal year 23 levels. For fiscal year 26, Judiciary requested a $9.4 billion in discretionary funding, an increase of $800 million or 9.3% over the 25 continuing resolution. Most of that increase, however, some 68%, is just to offset inflation, while the rest is for programmatic reassessment. Failing to fulfill that request would threaten the judiciary's ability to perform basic constitutional and statutory functions. I'm particularly concerned, Mr. Chairman, about our federal public defender program, which has faced a severe staffing shortage and budget shortfall for years. As a matter of fact, we made a mistake in this committee, and the Senate made a further mistake, which was corrected, which would have completely undermined the ability to perform the public defender service as is necessary. The Judiciary has requested $1.77 billion for defender services, an increase, a substantial increase of $315 million, or 22%, over the fiscal year 25 CR. Again, a freeze at 23 levels. Without that funding, courts will struggle to ensure that Americans are provided their constitutional right to an attorney, a competent attorney. We also need to ensure that our courts can keep up with the increasing caseloads. That means following through on the request to increase funding for the Court of Appeals and district courts by $345 million, or 6%. And again, for the Administrative Office of the U.S. Courts by $8 million, or 8%, over the 25 CR. Again, we're talking about 73 levels, essentially. Without these increases to help our courts hire staff as needed and cover basic operational costs, case backlogs will only continue to grow, making it harder for Americans to receive timely justice and due process. I know all the committee members understand this, but criminal cases must become before the civil cases because of the right to a speedy trial. That means small businesses and other Americans will be pushed to later resolution of their cases. We also need to devote more resources to keep our judges and courts safe at the time when Donald Trump and his allies are vilifying our courts. The public hears that, and it has a tendency to inflame those who may be irrational, may be mentally ill, or just may be angry. We ought to fulfill its request for a $142 million, or 19% increase above the 25 CR for court security. Now, court security is a euphemism for making sure our judges are safe, making sure that our judges are not intimidated, making sure that justice will be served unrelated to the threat of violence. I look forward to the hearing more from Judge Conrad and Judge St. Eve, although I want to say to you, I'm going to go back to my other hearing, going back and forth. But my staff will be here, and I'm going to hear everything you say, but it may not be, it may be virtually. Everyone who stands for law and order, Mr. Chairman, ought to be united in the mission of ensuring that our judiciary is safe, neutral, and articulating their thoughts regarding and opinions with reference to the law unrelated to intimidation and forces beyond their control. I yield back.
Thank you, Mr. Hoyer. Today we welcome the testimony of the Honorable Amy St. Eve, Chair of the Budget Committee for the Judicial Conference of the United States and dear friend of Magistrate Jonathan Greenberg, and the Honorable Robert J. Conrad, Jr., Secretary of the Judicial Conference of the United States. Without objection, your full written testimony will be entered into the record. With that in mind, we ask you to please summarize your opening statement in 5 minutes. Judge St. Eve, you are recognized for 5 minutes.
Good morning, Chairman Joyce, Ranking Member Hoyer, and members of the subcommittee. My name is Amy St. Eve, and I'm a judge on the Seventh Circuit Court of Appeals in Chicago. On behalf of the Judicial Conference Committee on the Budget, which I chair, I am pleased to appear before you today to present and explain the fiscal year 2026 budget request of the federal judiciary. Thank you for the opportunity to do so. An effective, efficient, and independent judiciary is foundational to the system of our government. Adequate and consistent funding is absolutely critical to conduct our constitutional and statutory responsibilities, and we are reliant on this subcommittee to help ensure that those resources are in place for us. The branch's fiscal year 26 funding request must be looked at in the context of the recently enacted continuing resolution for fiscal year 25, where every component of the branch was held to its fiscal year 24 enacted funding levels, regardless of any change in workload or other requirements. And for most of our accounts, this is the second straight year of a hard freeze. Among the impacts of the full-year CR are the deferral of dozens of judicial security projects at a time when threats against judges are increasing. The suspension of more than 2 months of payments to private attorneys who have provided constitutionally required representation to indigent defendants. The continuation of a long hiring freeze in federal defender organizations, and a year-over-year reduction in the allotments made to courts and probation and pretrial services offices to serve and protect your constituents. While the Judiciary's fiscal year 26 request of $9.4 billion may seem large, these resources are needed to rebuild and restore critical functions of the courts and the federal defenders that were not sufficiently funded in either fiscal year 24 or 25, and to address new and potentially significant workload increases based on the law enforcement initiatives of the executive branch. Our request includes $6.9 billion for the courts and probation and pretrial services offices. More than 85% of this requested increase in this area reflects just standard adjustments to maintain current services, with the remainder funding critical new investments in staffing, space and physical infrastructure, and information technology, including the next installment of funds that is essential for our multi-year cybersecurity and IT modernization plan. The Defender Services request totals $1.8 billion. Well over half of the requested increase in this account is needed just to mitigate the effects of the suspension of payments to private attorneys that was necessitated by fiscal year 25 by the full CR. The remainder will support current service levels and allow a resumption of hiring in the federal defender offices. We are also requesting almost $900 million for our court security program to address a complex and evolving threat environment facing judges and the judicial process overall. The request fully funds contractual obligations to our court security officers and helps recapitalize our systems and equipment budget, which was slashed due to 2 straight years of funding freezes in this account. The request also continues the expansion of our vulnerability management program, which was instituted to improve the safety of judges and their families after the murder of the son of Judge Esther Salas and the critical wounding of her husband in 2020. Finally, our request includes the $19 million that we project will be needed to fully fund grand and petit juror requirements for the year. As we ask the subcommittee to make the substantial investment in the judiciary, I want to assure you that we take very seriously our commitment to be responsible stewards of our funds. My committee has an entire subcommittee that is dedicated to finding opportunities to achieve efficiencies, adopt innovative business practices, and reduce or limit our costs without negatively impacting the quality of judicial services. At any given time, we have numerous cost containment measures that are at various stages of implementation, and those are described more fully in our budget request. Again, thank you for the opportunity to appear today and for your support of the judiciary. I understand that the fiscal year 26 budget we have put forward is a large one and that this is a difficult budget environment. But it is necessary to support the fair, efficient, and secure administration of justice in this country. I ask that you please make a part of the record my statement and those provided by the Court of International Trade, the Federal Judicial Center, and the U.S. Sentencing Commission, on whose behalf we submit requests. I would be pleased to answer your questions at this time.
Thank you, Judge. Now recognize for 5 minutes the Honorable Judge Robert Conrad.
Thank you, Chairman Joyce, Ranking Member Hoyer, Members Ivy and Cloud, and other members of the subcommittee. My name is Bob Conrad. I am the Director of the Administrative Office and Secretary of the Judicial Conference of the United States. Before being selected to this post by the Chief Justice, I served as a United States District Judge in the Western District of North Carolina for nearly 20 years. For a second straight year in FY 2025, our court security program received flat funding. We are concerned about this. We are also concerned about the increase in threats being made against federal judges and courthouses in the last several years. The independence of the judicial branch is jeopardized when judges are threatened with harm or impeachment on the basis of their rulings. Our constitutional system depends on judges who are sworn to administer justice without respect to persons. In doing so, they must be free from threats and intimidation. This is essential not just for the safety of judges and their families, but also to the pursuit of justice and equal rights for all. Threats of reprisals and retribution erode the rule of law. So we have safety concerns, compounded by the consecutive years of flat funding. I respectfully urge the subcommittee to fully fund our FY 2026 court security request. Second, we have in recent years discussed our need for additional resources to address the sharp increase in the number and sophistication of cyber attacks on the judiciary IT systems. The judiciary is a high-value target for cyber criminals. We have a classified briefing scheduled for next Tuesday, May 20th, to share some additional details on cyber attacks with House and Senate Appropriations Committee leadership and FSGG Subcommittee leadership. We do require ongoing resources to secure and modernize our systems, and we ask for the subcommittee's support. Third, I'd like to turn to our efforts to ensure a safe and respectful workplace for all judiciary employees. I'm proud to chair the Federal Judiciary Workplace Conduct Working Group, created by Chief Justice Roberts in 2018. For 7 years, this group, comprised of some of the sharpest, most experienced judges and other court leaders, have worked to accomplish the Chief Justice's directive to create an exemplary workplace. We have made significant improvements to our workplace conduct policies and practices. Last fall, we issued our first annual report on workplace conduct. In March of this year, we released the working group's analysis of the Federal Judicial Center's first national workplace survey of judiciary employees. The survey went out to 28,000 employees. A statistically impressive 50% responded. 91% of respondents indicated they had not experienced wrongful conduct of any kind. Over 80% responded that they were proud of their work and liked their jobs and would recommend their place of employment to family and friends. In addition, the survey showed us areas where we might improve, and the working group has issued additional recommendations to improve training, make reporting misconduct easier, and eliminate fear of retaliation. We will use the survey results to guide our efforts in making further improvements to workplace conduct policies. Turning to the AO budget, the FY 2025 full-year CR represents a second year of flat funding at the FY 2023 level. Because staff salaries and benefits comprise 96% of the AO budget, the impact of funding shortfalls rests almost entirely on our ability to retain and hire staff. For FY 2025, we are forced to leave a number of important positions unfilled. The AO's FY 2026 request seeks $110.5 million, a 7.6% increase above the FY 2025 enacted level. The requested $7.8 million appropriations increase is comprised of $6.2 million for adjustments to base for standard budgetary increases and $1.6 million to hire new staff to improve AO operations and enable us to better support the courts and federal defender organizations. My written statement discusses our need for new judgeships. Last Congress, we made the case for an additional 66 positions. The bill passed unanimously in the Senate and received post-election bipartisan support in the House. Unfortunately, it was vetoed at the last minute. The compelling case for new judgeships remains. My statement also discusses our new courthouse priorities, which are funded under GSA. Our top priority is a new courthouse annex in San Juan, Puerto Rico, which the Judicial Conference designated as a space emergency in 2020. I urge you to make yourself familiar with the plight of judiciary employees in Puerto Rico, working in trailers behind concertina wire, a courthouse that is outdated, unsafe, and built on a seismic fault line. It represents a compelling case for emergency funding, and I would ask that you heed our call. Our other space priorities are new courthouse projects in Hartford, Connecticut, Chattanooga, Tennessee, Bowling Green, Kentucky, and Anchorage, Alaska. All told, we seek $863 million in FY 2026 for GSA for these priority projects. Prepared to answer the subcommittee's questions.
Thank you, Your Honor. I first ran into the red, yellow, green when I worked in the federal court, so I know you've seen this before. But we try to make sure that everybody has a chance to answer questions. People will be moving in and out, so please don't let that bother you as you follow up. And a former defender and prosecutor myself, I understand that the publicity that sometimes comes to a judge, whether they want it or not, they're randomly selected. However, technology, social media, and the 24/7 news cycle have increased the likelihood that a judge's name will be reported on all media sites. This now leads to an unprecedented amount of attention on an individual who is responsible for overseeing a federal case. Would you describe the threat environment and how it has evolved over the last decade or so with respect to federal judges? And what is the federal judiciary doing to ensure that tragedies like the murder of Daniel and Darrell don't happen again?
The threat environment is dynamic and complex. And it's important and essential for us to have our court security account funded to address this. Not just outside of the home, but in the courthouse as well. There have been, since 2020, a lot of attacks on courthouses and damage to courthouses. The court security account funds our court security officers, who are really the frontline officers at courthouses, who screen individuals coming through and make sure that the judges, when they're there, are safe. It also funds the essential equipment at the courthouses, the screening equipment, the video equipment, the magnetometers, and it funds our vulnerability management program. The vulnerability management program is something that the courts have taken on to help get personal identifying information, or PII, of judges off of the internet. As you indicated, it's very easy to find things out, including home addresses of judges off of social media or the internet. And our vulnerability management program is an easy way to help judges pull that information off of the internet. As of April, 77% of our active federal judges have enrolled in the program and work with the specialists to help get this information off.
In addition to the Delete Me program, which attempts to remove personal identification information of judges from the internet, and which Judge St. Eve said almost 80% of judges have signed up for. We have taken steps to enroll judges in home intrusion detection system to protect them when they're at home, and also are engaged in hardening projects across the country with respect to our courthouses. So the threat environment is real. It's been present for a number of years, and the Judiciary and the United States Marshal Service takes it seriously, which is why we're asking for this funding.
I can attest to the fact that bomb threats and having my home swatted and using the programs you're talking about didn't take my home address off, because we still have to put it down on places like where we put in our application to run for office, the title of my home. And that's unfortunate. I understand you're going through the same problem. But as you realize, this administration has made cost savings a priority across the federal government. How would you elaborate on the judiciary ensuring that this fiscally responsible and the activities are undertaken with cost containment in mind? And are there internal and groups or programs to ensure that that is taking place?
Yes, thank you, Mr. Chairman. As I indicated in my opening statement, the Budget Committee has an entire subcommittee devoted to cost containment. And at any given time, we have various measures that are in place in a different place. Recently, one such engagement we had was to put in place a cap on spending that individual chambers can have on library books, encouraging more the use of electronic research and sharing of library materials. We are looking into the use of technology for detainees who are housed far away from federal courthouses so that probation officers and pretrial services officers and attorneys who are representing them don't need to travel, sometimes a significant amount of miles to go and visit with them, that they can do it electronically through equipment, and that would save quite a bit of money and time for all three of those categories. We are also looking at shared resources. My courthouse in Chicago, we have the Court of Appeals, the District Court, the Magistrate, and the Bankruptcy all in the same courthouse. So something that we recently instituted was we're sharing among the District Court, the Magistrates, and the Court of Appeals HR now. So we've combined those. And we're looking at doing the same for IT. Other courthouses are looking at shared resources that they can engage in. So at any given time, we have different things in place. As you know, we've had the no net new in place on our space, that courts cannot expand their space without giving up some. And we are focusing on space, which is quite expensive for us and a chunk of our budget. We are looking at other ways that we can save with space.
Thank you. As I said before, people are going to be moving in and out. I'm going to run down to a T-HUD hearing. The Vice Chair, Mr. Lalotta, will take over at this point. The Chair now recognizes Mr. Ivey from Maryland.
Thank you, Mr. Chairman. Glad to see my colleague is moving up to the big chair here. I do want to thank you all for coming in to testify. I certainly share the views of Mr. Hoyer with respect to the need for the increases for the judiciary. Cybersecurity, I think, is in particular is an interest of mine, having served on the Homeland Security Committee last year. But personal security for judges and personnel is a big one for me, too. We had a state judge who was assassinated in 2023. He'd made a ruling earlier in the courthouse that day. The aggrieved party followed him home and shot him in his driveway. And I'm aware of the case. I believe there was an individual who threatened, I think it was Justice Kavanaugh, and he's being prosecuted currently. So we know these things are out there, and we know they happen on both sides. I happened to work on the task force last year with respect to the attempted assassination of then candidate Trump. But I do want to say this, though, and I think it's important because there are these issues on both sides in the judiciary and beyond. I think what we say in politics and as elected officials is very important for us to pay attention to. I do think, as Mr. Hoyer pointed out, House Committee, Judiciary Committee Chairman Jordan's comments with respect to cutting funds to the judiciary, depending on some of your rulings, don't agree with that policy for sure. I think it impedes on separation of powers and the independence of the judiciary. But there are certainly others that have crossed the line. And ironically, I think now President Trump, certainly falls into that category with some of the statements that he's made. I think with respect to Judge Boasberg, who's practicing here in the District of Columbia, or he's sitting here in the District of Columbia, calling him a troublemaker and an agitator, calling him a crooked judge, that he should be impeached, I thought was totally inappropriate and over the line. Talking about judges as lunatics is another one that I think is bad. And then with respect to Judge Chutkin, who was sitting in one of his criminal cases, he said this judge is the most evil person during the pendency of that case. And I just don't think that's the kind of language that we should be projecting into the public, especially in these times, because we know these are polarized times politically. I know people have strong views out there about what's happening. I have strong views too, but I think it's important for us to not cross that line and say things that we think or should think could generate some sort of a violent response. And then from a legal and constitutional standpoint, the independence of the judiciary, I think that's critical too. I've got 7 House Republican colleagues who filed articles of impeachment against sitting judges. One of the judges I mentioned a moment ago is one of those 7. No showing or even allegation of wrongdoing, particularly just disagreement with the rulings that they issued in those particular cases that happened to involve the Trump administration. And they certainly have a right to their own views, but I think it's important for us, not so much because that might create an issue of violence, but just respect for the Constitution and what it should mean to when you start talking about impeaching judges. That's a big step. And I think, to my colleagues here and beyond, we should be very sensitive about making those kinds of statements and crossing those lines. When I was a staffer here in the late 80s, we impeached 2 judges. They clearly crossed the lines with respect to bribery, for example, and I thought impeachment was clearly merited there because under the standards set by the Constitution, they broke that, and they broke the trust of the American people. But throwing that term around, issuing articles of impeachment kind of willy-nilly is beneath what this institution should be doing. So thank you so much for the work that you all are doing. I know these are going to be challenging times with respect to seeking the increases that you're seeking. I share the need for the increase for federal public defenders, having practiced and been on both sides of that. It's critical to make sure we've got enough people there to handle the workload that's coming through. That workload is certainly in the District of Columbia is increasing, and we need to make sure that we're up to the task on that front and making sure that people have a chance to get equal justice. So thank you for the work that you do. I appreciate your testimony, and I yield back.
The gentleman's time has expired. I now recognize the gentleman from North Carolina, my friend, Representative Edwards, for 5 minutes.
Thank you. Thank you, Mr. Chair. Judge Conrad, with over 800 federally owned or leased court facilities, the judiciary is one of GSA's 3 largest tenants. How have organizational changes in the GSA affected the facilities of the federal judiciary?
We have an ongoing relationship with the GSA, both in terms of courthouse construction and maintenance. We have historically asked for more than they can deliver with respect to their funding. I mentioned the Puerto Rico emergency situation where the courthouse is outdated, unsafe, and built on a seismic fault line in a district where there's a very high volume violent crime caseload. And so there's ongoing efforts at doing things efficiently, but the ability to maintain our courts, and particularly our older courts, is in good times stressed, but in these times a real challenge for us. And so I met recently with the Public Building Commissioner. We have ongoing dialogue with the GSA. We've actually, in light of some recent developments, had the ability to hire some really competent GSA people who turned out looking for jobs, and they've come with us and bring with them a real knowledge of how things work on the other side and enable us to communicate better.
I recognize that 10 federal courthouses appeared on the now redacted list of non-core federal facilities released by the GSA. 6 courthouses currently appear on GSA's list of assets identified for accelerated disposition. How frequently does the judiciary dispose of properties from the real estate portfolios?
We have a Space and Facilities Committee of the Judicial Conference that looks at this question with some degree of intensity. I can speak from the district that you come from in the Western District of North Carolina. We, years ago, had 5 federal courthouses. We now have 3. And so that's an ongoing examination by our branch. And caseload changes, population changes are all taken into consideration. Resident or non-resident judges in courthouses impact the decision whether to close a courthouse or not. I've had 3 conversations this week with different judges across the country who are actively considering whether to close down a courthouse or keep it open. And so I think with our budget requests, we're also acting responsibly to try to contain our courthouse footprint and ask you for funding only when it's absolutely necessary.
Does the judiciary currently own or lease any courtroom or office space that's not currently occupied or in use?
I don't have on the top of my head the number of, you're asking about non-resident judge courthouses?
Well, any federal courthouse or office.
There are districts that have courthouses where judges travel from one courthouse to another to serve the needs of a different division. I don't have the exact number of those courthouses.
Final question is, when preparing for hearings like this one, I typically find Inspector General reports to be a really good resource for information on how agencies can improve their performance. And I really was intrigued to learn that while the Department of Justice has an Inspector General, the federal judiciary does not. And I was just curious to know your thoughts on why or why not should the federal judiciary have an Inspector General?
We are a separate and independent branch of government that is decentralized in its structure. And we don't have a single Inspector General audit. We have approximately 100 audits that go on every year from the various district courts across the country. We have an audit committee. Our governance is through the Judicial Conference, as you know, and we have 25 different Judicial Conference committees made up of volunteer judges and others who create policy for us, conduct audits. We have access to CPA firms that conduct audits for us. And our belief is that we're very responsible in the use of the funds that you give us, and that we're very careful with our Judicial Conference Audit Committee, with our Budget Committee, and the other structure that we have in place, that although we don't have a single IG audit that you speak of, we have the information necessary to tell you where the money is spent and how we're using it.
Thank you. I appreciate your time. Mr. Chairman,
Thank
I
you.
yield.
The chair now recognizes the gentleman from Texas, Mr. Cloud, for any questions.
Thank you, Mr. Chairman. Thank you both for being here. Thank you for the work you do in our all-important judiciary. I had a couple questions I wanted to bring up. One, I read through the strategic plan, and my understanding is those come out every 5 years, so we should be expecting another one this year. Is that correct?
Yes.
About when could we expect that?
We have spent time at the last 2 judicial conferences getting out the strategic plan to the committee responsible for it, to the other conference committees that have input in it. And
Is there a
that's
time? I'm sorry,
a
I
work in process, and
have a lot of stuff to go through, so is there a date that we can, roughly? I'm
the
not,
next judicial conference is in October of 2025.
okay, so is that when we would expect the report shortly thereafter?
Possible that it would be produced at that time.
Okay. You had mentioned, Judge Conrad, in your statement, the importance of us protecting judges against hurt or threats of impeachment. I think it's dangerous to combine those two in the same sentence. Against hurt, yes, we should definitely protect them. But that would be like you telling me that I should not be worried about what the people will think who elected me. Impeachment is a constitutional role to hold the judiciary accountable. And certainly, Congress created these courts with the exception of the Supreme Court, and that is our mechanism to deal with the legal system that's gone wayward. So we want to do everything we can to protect the judges and anyone involved in the legal process, but I think it's a dangerous ground to say that. And I was actually disappointed by this Chief Justice when he came out with everything going on in the judiciary right now, for him to come out and take issue with the president when there's a lot of work to be done within the judiciary is very concerning. Now, one of the big issues, and the second one in the strategic plan, which I certainly appreciate, was preserving public trust, confidence, and understanding. And it talked basically about the need to educate the public about everything that's going on. Now, a lot's happened in 5 years, and we've seen a lot of what some would say is lawfare. I certainly would agree with that. I think a number of Americans do. And I'm wondering what you will do as we approach the next strategic plan to deal with these sort of things, where we see lawyers who represent President Trump disbarred and threatened just for representing him in some cases, and then we see those prosecuting President Trump basically given a free pass. And so you could go down the long list of bad practices that has happened, but from Jack Smith to Fannie Willis was disqualified from the case, and Nathan Wade from his case, but neither of them have faced disbarment. Alvin Bragg turned a misdemeanor into invented law, basically, in order to bring indictments. He has not been referred to for disbarment. Letitia James has been basically under investigation for the very thing she accused President Trump of. And Elise Stefanik and others have called for her to be disbarred. Has not been referred. So we see a duplicity here, and that's where we're getting a lot of the mistrust that the Americans have in the judiciary right now. I'm wondering what your strategic plan will do to address those concerns.
I'd like to go back to your first comment and work from there, where you identified that in my opening remarks I had referred to the physical security of judges and impeachment in the same phrase or sentence. And your point's a fair one, and I take it
Thank you, sir.
as a clarification. From the independent judiciary's perspective, they do represent two harms. The first harm is to judges and their family members who have been threatened either by intimidation or actual physical violence. In the last several years, the marshals have
We've met with
thousands.
the Supreme Court and the administrative judge, and we've discussed this. I don't think there's debate across the aisle as to whether or not we should protect judges, at least hopefully in this chamber.
And then the second
My
part,
concern is, what are we going to do to restore trust in the American people in a judicial process that seems very partisan? For example, district judges who think that they can impose executive mandates. I mean, you go read Federalist 78, and it's very clear the judiciary will have no force or will over the purse or the sword, and yet we have a number of judicial judges who seem to think that they've been elected president.
and our system for 250 years has functioned with one branch having the sword, one branch having the purse, and the third branch being supposedly the least dangerous of the branches. There is disagreement, strong disagreement, passionate disagreement with the rulings of district court judges. Our tradition of justice has been to challenge those rulings, to appeal them, and to get the ruling that you think, as a litigant, you're entitled to. It has
The
never
question
been-
was what were you going to do in the strategic plan? And my time's up, Chairman, but
Thank you.
that's the
The
answer.
chair now recognizes the gentlewoman from Iowa, Ms. Henson, for 5 minutes.
Thank you, Mr. Chairman. Good morning. Thank you so much, Judges Conrad and St. Eve, for being with us today and answering our questions. In my district in Northeast Iowa, we are home to the Northern District of Iowa for the U.S. District Court, and we are very blessed to have the leadership of our Chief Judge, C.J. Williams, and the strong presence of the court in our community. So I just want to say thank you to the great people who work in our federal courthouse. My office also happens to be in the building, so we get to see them on a regular basis. And I know how committed our officials are to really protecting the integrity of their operations, and I do want to make sure that they have the tools necessary to respond to the evolving threats that we're seeing. And I'm running back and forth between the Homeland Security Subcommittee meeting and this one, and so I just want to go to kind of an issue that kind of ties into both. I also serve on the Select Committee on the Chinese Communist Party, and I remain deeply concerned about the state-sponsored cyber attacks and threats that we've seen coming out of the CCP. This really affects all branches of the federal government, including the judiciary. So we've seen how those actors with the PRC are really targeting our federal networks, the critical infrastructure there, and even attempting to exploit many of those vulnerabilities within our judicial institutions. So given this threat landscape that we continue to see from the PRC, what specific steps are being taken to ensure that the judiciary's IT systems and applications are protected from these attacks from foreign adversaries? And is there a higher level of coordination happening with CISA, with the marshals, other federal agencies to ensure that these systems are safe and secure?
Yes, thank you. The cybersecurity has been a priority of the judiciary, especially since 2021. We have an IT committee that focuses on this, and yes, we are coordinating with CISA. We've gotten input from them on our systems. We've coordinated with the Director of Cybersecurity. We have a 5-year plan that we started in 2022 with this committee. We submitted a 5-year funding plan for cybersecurity and IT modernization. On the security side, we've implemented a lot of changes, including zero trust architecture, multi-factor identification. So a judge or a staff member can't sign in at their desktop or remotely without dual authentication now. That's one of the standards we've been recommended to put in place. We're also putting a great effort forward to modernize our equipment. Some of it's obsolete, and because it's so old, it's really at a security risk. So by modernizing our equipment, we are prioritizing security with that new equipment, and with that just comes increased security procedures. So we thank this subcommittee because a couple years ago, we had a cyber debriefing, and we talked about a 5-year plan, and we put a 5-year funding plan in place. And it's important that we continue to get that money, and we have been putting it to good use.
Yeah, well, I would love to get some more details on some of the other things that you've put into place, just kind of an accounting of that so far. So a 5-year plan, obviously kind of then up in 2027 to kind of look at maybe next steps there. Just want to make sure that we're keeping pace with what we need to keep up with that threat.
Happy to do that.
Yeah, so I appreciate that, maybe on follow-up. And then one quick question, as my time is coming into end. When I look at a rural state like mine here in Iowa, we know that there can be some barriers to accessing federal courts. We know, you mentioned judges that are going back and forth. I had a lunch with the chief judge a few weeks ago to talk through some of those concerns, especially as the caseloads continue to grow. So what are some of the challenges that courts are facing in managing this demand, and how critical is it that we have the adequate number of judgeships to meet those growing caseloads?
So thank you for that question, because I do think there is a need that we proved last year for more judges, and hope to use the momentum that we established with the Senate and the House last year in terms of all 3 entities agreeing with respect to that need. We have a judge's bill that is currently in the House right now. Our judicial conference has recommended 69 new district court judge positions and 2 appellate court positions. And those are based on a very careful study of the 94 districts in the country and the places where judgeships are most needed, and so that is an area where we could benefit tremendously if the positions were created.
I think it's the Judges Act, so yeah, absolutely. Well, I appreciate you testifying today, and I think I'll stay tuned for round two. Thank you, Mr. Chairman.
Thank you, Ms. Henson. And Chair now recognize the gentleman from Maryland, Mr. Hoyer,
I want to thank the
ranking
chairman.
member.
Thank you very much. I don't have any questions, but I do want to make an observation, Mr. Cloud's comments. I've been here a long time, but in the history of the country, I do not think we've had, well, I mean, in recent times, we have not had the challenge to the Congress's authority as we've seen in this administration. There are judges, including the Supreme Court, who have concluded on a TRO basis or a temporary basis, I don't know of a final decision, but that the administration is not following the law. Mr. Cloud observes that the district court judges are somehow accruing to themselves executive authority. I differ with the gentleman. What they are saying is, in their judgment, the executive does not have the authority that they're exercising. That is what checks and balances means. That is the essence of our democracy. That is the essence of how one branch checks the other branch. And I want to make it very clear that the disdain that is directed at judges for saying that the executive department is not acting consistent with the law and with the separation of powers is not accruing to itself executive authority. It is doing its job of asserting what the balance, correct balance under law and under the Constitution is between the three branches of government. I, for one, would hope that judges would continue to do that. And very frankly, I've been upset with judges in the past, as we all get upset because we disagree with them. That's our democracy. We disagree. I've disagreed strongly with the Supreme Court, but I've never suggested that therefore one of them be removed or a group of them be removed because of decisions that I didn't like. We have a structure to do that. We have constitutional amendments, which are very difficult. We have statutory law, which is not nearly as difficult. And we have elections for presidents and Congress to change policy. But I want to make that observation, Mr. Chairman, because I think the assertion that somehow judges are accruing to themselves authority which they do not have is inaccurate. Thank you. And I'm going to go back to my other hearing now, Mr. Chairman. It's a balancing act.
Thank you, Mr. Hoyer. The chair now recognizes the gentleman from New York and the vice chair of this committee, Mr. Lalota, for any questions he may have in 5 minutes.
Thank you, Chairman. Before I get to my questions, I'm going to yield a minute of my time to Mr. Cloud.
Thank you. I'll keep this really brief. I appreciate Mr. Hoyer's thoughts. I would point to the Biden administration who willfully did not listen to the Supreme Court when it came to student loan programs, among other things. The district judge's jurisdiction is in the title itself. It's a district judge. And the idea that they can have these federal injunctions that limit the president's executive authority that's clearly given to him in the Constitution is well beyond the Constitution and should be dealt with by this Congress, including impeachment.
Thank you. Judge St. Eve, how are you?
Good, thank you.
Thanks for being with us today. You mentioned earlier the increased prosecutions tied to immigration crimes, including illegal reentry and cartel-related trafficking. Your Honor, do you believe we need more immigration judges in this country?
We probably do. That's outside of Article 3 and outside of my specialty. I get appeals from the Board of Immigration after they've gone through immigration judges, but in terms of our budget, that is outside of my expertise.
You have 23 years on the bench.
23 years on the bench,
District
but-
courts, you're now a Circuit Court of Appeals judge, pretty prestigious, must come with a ton of experience. Just as a matter of judicial efficiency, supply and demand concepts. A lot of immigration, court cases coming before our courts. Would we be able to dispense with them more expediently if we had more judicial staff?
Yes, what I see in appeals is they get backed up because of the volume going through immigration. So yes, from a pure efficiency standpoint, more immigration judges would be able to help process the immigration proceedings.
And based on your 23 years' experience on the federal bench, what's the consequence of judicial inefficiency, specifically with respect to not being able to dispense with some of these immigration cases?
It clogs up the system. The delay, you see some things that take years to complete, that backs up everything behind them. So, and it's expensive.
Sure. So let's talk about asylum for a moment. My understanding is roughly 3 of every 4 asylum claims are adjudicated in the petitioner's, against the petitioner's request. That 3 or 4 don't qualify for traditional asylum. And yet, the standard of this country has been, at least under the Biden administration, when somebody claims asylum at the border, Biden paroled them to the interior of the country pending their immigration case. It takes years often for that case to be heard. So isn't it a consequence of a judicial inefficiency, those years that it takes to get to those cases, these folks, 3 or 4 who don't ordinarily qualify for this, isn't the consequence you have a bunch of folks in this country who are not really here under the authorities traditionally granted under asylum?
It's hard for me to generalize like that and say it's because of judicial inefficiency. I don't know, some of the appeals that I see, there are lots of extensions requested by the lawyers. There are extensions requested while you're waiting to get a lawyer. So I think it's hard to make a general statement that everything could be blamed on judicial inefficiency.
I'm surely not blaming everything on it, but I would posit that you have a lot of folks in this country who feigned asylum on their way in and took advantage of the system that was laid out to them, probably not fault of their own. The door was wide open. They got paroled into the interior country. A lot of them found their way to New York where they got the free hotels and the health care, and it was an incentive to get there. What I'm offering is, if we had a quicker judicial system, more judges to dispense with these cases, we can get to the point of the game where, okay, you don't qualify for asylum, now you got to go back home. So my question, Your Honor, is what is the judiciary doing to get to a proper staffing?
So for staffing for us, and again, immigration is not within the budget request that I'm here testifying about today, but in terms of staffing, we have work measurement formulas based upon real statistics of what our caseload is. And the staffing we request that's in our salaries and expenses account is based upon those work measurement formulas and what our anticipated workload is and what the anticipated caseload is. And that's what we base our budget on in our request.
Great. Real quickly, with a few seconds I have remaining, with respect to the border district courts, are they getting the judges and the staffing they need, or are we stretching existing personnel too thin?
We are definitely stretching existing personnel too thin, and I think in addition to the staff, the court staff and the staff in the clerk's offices, there's probation and pretrial. And at the border states, when you have a lot of defendants who are coming through, that really stretches the resources of the pretrial services officers and the probation officers.
Thank you, Your Honor. Your feedback is valuable to us. We appreciate it. I yield.
Thank you, Congressman.
Thank you very much. The chair now recognizes the gentleman from Missouri, Mr. Alford, for any questions he may have.
Well, thank you very much. I appreciate that. Good to have our witnesses here. Appreciate your time for coming here. Justices today face unprecedented threats to their personal safety. In an era of social media, mobs who disagree with legal interpretation share personal identifiable information on social media. These online mobs encourage violence against judges and will dox their home addresses, familiar information, and anything else they can get their grubby little hands on. Judge Conrad, how does the Judiciary's Threat Management Branch help remove this information from the public domain, and what can Congress do to ensure the safety of folks like you?
So for a number of years, we've been active in trying to get the Daniel Andrew.
Is your mic on, sir? Would you please start over?
For a number of years, we've been very active pursuant to Daniel Anderl bill and other efforts at getting both in state courts and across the country that personal identification information offline. And we have encouraged judges to sign up for delete me type protections where the internet is scrubbed for personal identification information. And over 80%, or near 80% of our judges are engaged in those kind of efforts.
What do we need to do to get all of them involved in those efforts?
But we do, at every judicial conference across the country, we have a component that deals with judicial security and encourage best practices with respect to our judges.
Just over a month ago, a California man pleaded guilty to attempted murder of Justice Brett Kavanaugh 3 years ago. He was arrested outside the justice's residence with a gun, a knife, zip ties in the wake of Supreme Court's Dobbs decision. While I understand the Supreme Court handles their own threats, has the rest of the judiciary moved to strengthening security after potentially large decisions like that could sway action by mentally deranged people?
Yeah, we have active coordination with the United States Marshals Service and try to surge resources to areas that we can anticipate problems. We have requested funding for courthouse hardening projects that will provide security to courthouses, and we have encouraged judges to and supported them financially in obtaining home intrusion detection systems. And so we're pretty focused on the home and the courthouse. Sometimes the vulnerability is in between.
How much money do you need from us to make sure that those programs get put in place, that we protect our judiciary?
Well, we are asking for our court security account, $892 million. That funds our court security officers, the vulnerability management program that Judge Conrad just mentioned, and it also funds updating security equipment in the courthouses. And it's really needed for that last piece because that account has been frozen for the last 2 years. So we've had to take money from that account that was intended to update our equipment, to put new cameras in, new security measures in. We've had to take that money and use it to pay for the court security officers and the vulnerability management
It's
program.
called robbing Peter to pay Paul. What
Exactly.
happens if we don't get this funded?
That equipment will become more obsolete and increase security risks at courthouses around the country.
Mr. Chair, I respectfully submit that we take a good, close look at this. I know we will because this is a precious part of our government. We need to protect those who serve us through the judiciary. And with that, I yield back. Thank you, sir.
Thank you for that observation, and the chair totally agrees with you. The chair now recognizes the gentleman from North Carolina, Mr. Edwards. More questions?
Thank you, Mr. Chair. Let's turn the conversation to technology. Something I think we don't spend nearly enough time talking about. And when I look at your budget request and the historical spending, I see that the federal judiciary spends, let's call it about $1 million a year, which doesn't seem like a whole lot of money, but I know that often money towards technology goes into a big old black hole. Can you tell me a little bit about how that $1 million or so is being spent? How much of that is on maintenance? How much is on new software development? The portion on new software development, how do you know we're getting our money's worth out of it? I was an appropriator for technology back in North Carolina when I served in the Senate, and I know we invested tens of millions of dollars in new development. Years later, we'd run into a roadblock and realize we've wasted all the new development money that we had, and we had to start over again. I'm just curious, are you finding those types of issues? So when it comes to the JITF funding, how is that being spent? What are your concerns?
Okay, thank you for clarifying that, Congressman Edwards. If I understand, you're asking in particular about our money into JITF.
Let's start with that.
Okay.
And then tell me if there's something else that I'm not looking at.
As opposed to some of our cybersecurity efforts and the
Yeah,
5-year
separate
plan.
from
Okay,
cybersecurity.
thank you for that clarification. So our systems are becoming obsolete. And for years, we did not put money into IT.
Common story.
Yes, yeah, but for a long time, people thought IT was the, oh, I need my printer fixed. And it's changed dramatically. But for years, and because we try to be good stewards of the money, we put our priority elsewhere. And as a result of that, we lost people in IT, and our systems have become obsolete. So the money that goes to our IT account is going really to rebuild those systems and to modernize them, and along with that modernization comes security. Part of that money goes to bringing on and keeping IT personnel, which is, as you probably know, very hard to do because a lot of IT personnel can earn a lot of money if they go outside of the government. And so trying to keep those people is very important to us. But we really depleted our IT to a large extent in terms of personnel, and we've been trying to increase that because it's essential to keeping our systems secure and modern.
I will, Mr. Chair, I'm going to submit some written questions. I'd like to understand more about the investment in IT and where you see the future. But let's shift to AI now. Where does artificial intelligence fall into the overall platform or plans for the federal judiciary?
So the director, and maybe I'll let you answer this, has put together an AI task force.
Recently, and it's directed both at the ways in which AI can be of benefit to the justice system and in ways to prevent it from being destructive. And so the task force consists of gifted people across the country identifying the AI issues that we deal with now and hopefully anticipating them in the future. That task force has been recently comprised, and we look forward to learning a lot through it.
Will you be sharing the results of that task force with this committee?
Be glad to, yes, sir.
That'll be one of my requests in my written follow-up. Thank you, Mr. Chair.
Thank you, sir. Mr. Alford is good with his questions, and I appreciate your time here today. With that, I know this has been very engaging and fun for you, and our time has concluded. But I'd like to thank you both for being here today. I know, as Mr. Edwards has indicated, there may be members who would like to submit questions for the record. I ask that they submit those records for the subcommittee staff within the next 7 days. And with that, this subcommittee stands adjourned.